Hi guys, and welcome to the Law on Extinguishment of Obligations Part 6. Okay, today we will be talking about compensation. Okay, so if you like my videos and you want to see more, please hit the subscribe button. Now for my regular viewers, please be reminded that this is merely for educational or informative purposes and is not a substitute for proper legal advice. For my students, please be reminded that this is additional study material and is not meant to constitute a substitute for studying or understanding the law. Okay? So what is compensation? Compensation is the extinguishment to the concurrent amount of the debts of two or more persons who are, in their own right, mutually creditors and debtors of each other. In other words, the debtor already has a debt in favor of the creditor, and for some reason, the creditor has a debt in favor of the debtor. Okay? In that case, in order to prevent unnecessary litigation where they both have to file claims against each other, the law allows them to set off each other's claims against the other. Okay? So now let's move on to the kinds. Under Article 1281 of the Civil Code, we have total or partial compensation. In case the debts are equal in amount or value, then they will be totally compensated, which also results in total extinguishment of the obligations. Okay? But where there is a smaller debt and a larger debt, there will be total compensation as to the first smaller debt, and there will be partial compensation up to the amount of the smaller debt in case of the larger debt. Okay? So there's only partial compensation, and the obligation is also partially extinguished only. Next, we have legal compensation under Articles 1279 and 1290, which takes place by operation of law. In other words, there is nothing more for the parties to be done. As long as there is compliance with all the requisites of compensation under the law, then the debts will be compensated. Okay? This is of course subject to payment of expenses for exchange or transportation. Okay? Next, we have voluntary compensation, or that which is agreed upon by both parties. Unlike in legal compensation, which only contemplates present and past debts, voluntary compensation may contemplate future debts as long as the parties so agree. Okay? Next, we have judicial compensation, or that which takes place when a claim for damages is set off against an obligation and it is contained in a judicial order or a final judgment. For instance, A has a claim of money against B. When A sought to claim the debt from B, B did not pay. So A, in his anger, damaged the property of B. Now, when A filed a case to collect the sum of money from B, B can now set up his claim for damages on his property against A to set off his debt against A. And finally, we have facultative compensation, or that which can only be set up by one of the parties to the obligation, which takes place in Article 1287. Now let's move on to the requisites under the law. Okay? The first requisite, each party must be principally a debtor and principally a creditor of the other. Because there may be some parties to the obligation who are not the principal parties or those who are primarily liable, such as in the case of a guarantor, which is actually the exception to this case. This exception is provided in Article 1280, and it says that a guarantor, a party who is not primarily liable, can set up compensation against the creditor of his debtor to the extent that of the debt which the creditor may owe the debtor. Okay? Why? Because the extinction of the principal obligation of the debt that the debtor owes to the creditor carries with it the extinction of the accessory obligations in accordance with the rule that the accessory follows the principal. So again, in case the principal obligation is extinguished by virtue of compensation, the guarantor can invoke that compensation against the creditor so that the creditor can no longer claim against the guarantor. That's the exception to the first requisite, that each party must be a principal debtor and principal creditor of the other. Okay? Second requisite, both debts must be in a sum of money. Okay? It must be a sum of money. This is emphasized in Article 1287. No? Contracts of deposit or comodatum or support, these cannot be compensated. Why? In a contract of deposit and comodatum, trust is an essential requisite of these contracts. Okay? So, the object itself cannot be compensated against a pre-existing obligation in money. Okay? Now, for support cannot be compensated because it is essential for survival. However, if support is for past support, like support in arrears, this may be subject of compensation because the person claiming support has already survived in the past. What cannot be compensated is current legal support. Okay? Now, moving on to the next requisite. Both debts must be due. Okay? They must be due. The exception here is in cases of voluntary compensation, where parties may voluntarily agree that future debts may also be subject to compensation. Next requisite, both debts must be liquidated. In other words, they must not be uncertain, such as a share in an estate or a share in partnership. No? Those are uncertain. Both debts must be liquidated in a certain amount of money and demandable. Okay? So both debts must be liquidated and demandable. And the last requisite, there must be no retention or controversy by third parties which is communicated in due time to the debtor. In other words, there is the creditor and debtor relationship. And here now is a third party claiming that he is either a creditor of the debtor or that the creditor owes him money which the third person has now attached through garnishment. In that case, compensation cannot take place between the creditor and the debtor. Again, the 5 requisites are: first, each party must be principally a debtor and creditor of each other. Second, both debts must be sum of money. Third, both debts must be due. Fourth, both debts are liquidated and demandable. And 5, there is no retention or controversy by third parties communicated in due time to the debtor. Okay? Now, let's go through some rules. Okay? First, when one or both the debts are voidable or rescissible, they may also be subject to compensation. I will be discussing voidable and rescissible contracts in another series of videos. But for now, all you need to understand is in case of a voidable or rescissible contract, these contracts are valid until they are annulled by a court order. Okay? So in this case, since they are valid until annulled, then they still can produce effects. And while still valid, they may be proper subjects of compensation. Okay? Next, before I discuss this next principle, I want to explain a little bit to you about what assignment is. Okay? Assignment or assignment of credit is a contract. It is a contract by which one person transfers to another, okay, his rights or actions against a third person in consideration of a price certain or in money or in its equivalent. Okay? So in other words, we have the creditor and the debtor. Okay? A creditor may assign his rights to a third person who now becomes the new creditor of the debtor. Okay? Now, there is a difference between assignment and negotiable or negotiation under negotiable instruments. While in negotiation under negotiable instruments law, the new holder may gain greater rights or a better title than the prior parties. In assignment, the assignee or the third person who becomes the new creditor merely steps into the shoes of his assigner and gains no better right than his assigner has. Likewise, he does not warrant the solvency of prior parties. So why did I discuss this? Because compensation may take place during assignment. Okay? First, what if compensation takes place before assignment? Then, it may be invoked by the debtor as a defense because the obligation had already been extinguished. Okay? Again, let's say the creditor assigns his rights to the third person who now becomes the new creditor. But before this assignment, the debtor had already compensated his debt against the creditor. So technically, there is nothing for the creditor to assign. So when the creditor assigned and the new creditor now goes against the debtor to claim the debt, the debtor can now invoke as a defense, no, that debt has already been compensated. Okay, so it is a matter of defense. Okay, now let's talk about what if compensation takes place after assignment. In other words, creditor and debtor, the debt has not yet been compensated. And then, the creditor now assigns his right to this third person who now becomes the new creditor. What are the rules? Okay? First, what if the assignment was with the consent of the debtor? In this case, the debtor cannot set up the compensation against the assignee. Why? Because the assignment was with the debtor's permission. He has in effect assented and consented to the assignment, which creates a new juridical relation between this third person and the debtor. Okay? So now the debtor can no longer claim compensation against his new creditor. But now what if, second scenario, the assignment is with the knowledge but without the consent of the debtor? Then the debtor can only set up compensation up until the date of the assignment. Okay? So in other words, here's the creditor and here's the debtor. On the date that the creditor assigned it to this new creditor, the debtor can only claim compensation up to the date that the assignment took place. Finally, the last scenario is in case of assignment without the knowledge of the debtor. Okay? In this case, the debtor may set up compensation against all. Okay? All debts until he learned of the compensation. Of course, when the debtor already has knowledge, then he is already charged with knowledge of the compensation, and he is stopped from claiming otherwise. Okay? So I hope you have picked up a thing or two on the law on compensation. Please check in again for the next video on novation. Okay? So see you next time. Bye.